You might have heard that the Nigerian Supreme Court on Tuesday adjourned hearing the application filed by the former governor of Imo State, Emeka Ihedioha, for a review of the judgment that sacked him as governor. The case has been adjourned till March the 2nd to allow the opposing parties to complete and conclude the processes for filing and serving their various pleas and applications. Mr. Ihedioha of the opposition PDP is asking the Supreme Court to set aside its judgment delivered on the 14th of January in which it nullified his victory in the governorship elections held in March last year and declared Hope Uzodinma from President Buhari's ruling APC party the winner of the ballot after he presented results that had been excluded from nearly 400 polling units. But the application for a review of the Supreme Court's ruling has been vehemently opposed by the Uzodinma legal team as well as his supporters on the streets. We'll hear from both sides in a moment. But first, let's hear reaction to the decision to adjourn the case.
The application was brought by Honorable Ihedioha and PDP, People's Democratic Party. It's a joint application, and in that application, they seek the court's orders to set aside the judgment of this noble court entered against them. And the gravamen of the application is simple, that judgment was obtained by fraud, that the appellant in that appeal, Hope Uzodinma, obtained the judgment by fraud. And in that application, we set out the grounds of fraud. And we hope at the end of the day that the court will look at it dispassionately and then hold favorably to our prayers.
The judgment of Imo State was sound and straightforward. 7 justices of the Supreme Court sat and took a decision. No single dissenting judgment. And you are telling them that they don't know what they did. Any form of appeal against the Supreme Court judgment is desecration of justice. Our law does not support it. The law of Nigeria permits what we call the slip rule, where you can correct clerical errors, not for the Supreme Court to undermine its integrity. If you tell the Supreme Court through blackmail to revert its judgment, it means that you are setting another Supreme Court above the present Supreme Court. Can you appeal the judgment of the Supreme Court? The answer is no.
Well, to debate this nettlesome legal and political issue, I'm joined now in the studio by the former presidential political advisor, Ahmed Gulak, who supervised the APC nomination panel that selected Hope Uzodinma as the governorship candidate, and by Barrister Emeka Ihedioha, a legal practitioner representing the Emeka Ihedioha campaign to reverse the Supreme Court's decision. Thank you very much indeed to both of you. And I'll start with you, Ahmed Gulak. I mean, let's be clear on what the issue is here that led to Hope Uzodinma legally protesting all the way to the Supreme Court. His case was specifically focused on what he said was the wrongful exclusion of valid votes already signed and validated by the electoral umpire. Is that correct?
Correct. You have said it all. You have captured it vividly. Elections are held at the polling units, not at the ward, not at the local government, not at the state. Once a presiding officer conducts an election, enters the result in what we call Form EC8A, he signs. The agents who are willing will sign. And the presiding officer takes the top copy and gives each agent other copies generated from the top copy registration and gives security agents their own copies. This is what happens at the elections, at the election units. And now these results from the polling units are now collated at Ward Collation Center, where these election units results are put into Form EC8B to determine in that ward who won. You can win in Unit A and be defeated in Unit B, but the total collation at the ward will determine in that ward who won and who lost. Then from the ward, they go to the local government collation center, where you enter the results collected in from EC8B to EC8C to determine who won in that local government and who was defeated. Then from the local government, you go to the state to collect, and there, totally, the winner will emerge. In Uzodinma's case, his results in 388 units were excluded, not cancelled. Cancellation is different. When the presiding officer who has the record cancelled results.
Well, there must have been a reason why they were excluded. And that reason was enough for the tribunal as well as the Court of Appeal
there was no reason.
to answer to determine in favor of Emeka Ihedioha.
No reason was given. You know, when you file a case in court, you settle your pleadings. Hope Uzodinma said his result in 388 units were excluded, instead of them to add in the wards and the local government, they were excluded.
Right, okay.
That's his case.
Okay, well, let me bring...
Now, in that case,
right,
it was incumbent on INEC to say that, no, that result from 388 units is not correct. This is the correct one. They failed to adduce.
Okay, just hold on a minute. Let me bring in Barrister Emeka Opara in, because according to Mr. Uzodinma's contention, 213,695 votes were wrongly excluded, and Mr. Ihedioha was returned as governor based on a wrongful computation of results. From 2,883 odd sort of polling units. And the Supreme Court has now agreed with Mr. Uzodinma.
I want to tell you, with every degree of responsibility, that this narrative that is being peddled is totally not part of the facts. Now, grandstanding, Nigerians are very well known for grandstanding, and that is what is happening now to change the narrative. Now, I have fully read the records, and I was present in the tribunal when Hope Uzodinma gave his evidence. I was present when the police officer came to give evidence. And if you get to the records, leave my own notes aside, if you get to the records of the tribunal, you will discover that all the things that they are peddling, they are all false. Now, look at what happened. Now, let us, Mr. Gulak talked about the pleadings. I do not know whether he has read the pleadings, but what I can tell you is that when you plead, somebody has to reply. You pleaded that 388 unit results were excluded, and INEC pleaded, and the other party also pleaded.
And INEC is the Electoral Commission.
Of course. The electoral umpire said, look, in these 388 units, there were either results we are not, election we did not hold because of violence, and we filled from incident forms, which is in the electoral law is required in such a case. And look at them. In some cases, they were marred by violence midway.
And it is perfectly understandable that the Electoral Commission, who is the person conducting that election, can say that, you know, hey, these results are not valid because they were marred by violence or whatever else.
And this is what happened. When you said that, in your own pleading in reply, what it means is that the person who said these are authentic results should come and tell you, because you have put in that respect, you have put the issue whether elections held were completed in those units, you have put it on, it has become an issue. You put it on issue. And that is what happened, and that is what the tribunal specifically captured. Now, you never, out of 388 units, you never brought a unit agent of yours to come and give evidence and say, look, election held. You brought about 38 or so agents from, I'm happy he said it's from, this is issue of units. Now you brought some from the local government, from the ward level, and those people under cross-examination, they were asked, were you there in this unit? Did you vote on that day? Yes. Were you there on such and such a day? They will say no.
Okay, I'm going to bring in Mr. Gulak in, but let me just be clear on this. Your argument, and your consistent argument, is that those polling units, the results from them were declared inadmissible by the Electoral Commission.
The results peddled by Senator Hope Uzodinma.
Right, okay.
Not results from there.
Okay.
There were no results.
Okay.
And
I want
to say something.
No, just hold on. I don't mean, you'll have another chance, but we must balance this. We're going to take a break shortly. Ahmed Gulak, your response to that.
One, it is unfortunate that people just talk out of the blues. The pleadings were settled. All parties, including INEC, including APC and Hope Uzodinma, all parties agreed elections held in Imo State on that day peacefully. PDP said it, APC said it, INEC said it, in their pleadings.
So why did the tribunal, all the rest of them, find against
your the tribunal admitted in evidence the unit's results of 388. After a lengthy argument, if he was in the court, he will bear this witness. The tribunal, after marathon argument from counsel, after fireworks of legal fireworks, the tribunal admitted these 388 unit results. But in its ruling, it expunged it, meaning sitting on appeal over its own ruling, which is not allowed in law.
Can I say something?
Very
quickly.
It is important I say something on that.
Secondly,
let me bring him in to respond.
It is important I say
Very
something on that.
Yeah.
You have allowed me to land and let him pick it so that we can have
he's right, actually. Let him finish.
Of our reasoning.
Okay, very quickly, because we're taking a break in a minute.
One, the trial tribunal, after admitting in evidence the 388 unit results of Uzodinma after legal fireworks, in its judgment, now sat on appeal on its own ruling and expunged these 388 unit results.
Okay.
When INEC did not contest, did not bring any result to counter it.
I think you've made that
PDP
point.
Did not contest, did not bring result to counter it.
Okay.
And, hey man,
you've made,
is legally admissible, and the court was
hold on. Emeka, for your response.
Now, for those who do not understand, every court of law, especially election tribunals, whatever document that is brought to you, you must first accept it. It does not mean that they will be the determinant of the judgment. And that is what was done, because all these were not even admitted through witnesses. They were brought in by counsel. And the rule of election tribunals, because of the time bound, the time of it, is that you have to take in everything. And then when you are considering, which is the rule of law, practice is that when the court is now considering its judgment, considering the evidence, the court will now decide, document A, evidence, exhibit this, did I admit it rightly? After going through this thing, the court will now make a decision. This is not like the court admitting in full legality these documents. So what he's saying is simply to pander to people who do not understand the way it operates. That is what I can tell you there. Now the issue, let's return to the facts. It is issue. Now when you look at this 388, where would you find a result where the number of votes, for example, in serial number 69, where the number of votes is more than the number of registered voters in that unit? Where would you find in about 214 units out of those 388, the number of votes that supposedly we are giving to Hope Uzodinma were more than the number of collected PVCs? In 214 out of that. And this is pure illegality. It is only in this country you see this kind of thing. Now, if you go out of this country, you find out there are two issues, especially that every country that wants to go forward take very, very important.
Rule of law,
and that is
one of them.
The rule of law, of course. We are talking of when you're talking of somebody going to forge the national currency. Now, somebody forging election results means you are taking away the whole foundation of democracy. And it is only in this country we will be talking about this, because if it were in any country that really wants to go forward, we should right now be talking about what are we going to do about this. Throw the whole book of the law at him, at the people involved in this haste, in this kind of criminal forgery. That is what and this is
okay.
what
this is objectionable.
This is what the Supreme Court.
A lawyer is not supposed to talk like this.
I'm
sorry to say, if you have to go and read your law, read your law.
Sorry.
Issues of criminality, whether you call it criminality or fraud, you ought to have pleaded it in your pleading in the trial tribunal. What we are saying is that when you are alleging some people went and forged the document, this is an allegation you cannot prove. Allegation that was before the tribunal is that this is my result, 388 unit result that was excluded by INEC. INEC ought to have brought a result to differ from Hope Uzodinma's result. This is, by the way,
so they
are now in Supreme Court
right, okay.
for review.
Yes, I see what you mean.
I am trying to say that the term for election matters have already elapsed.
Right, okay.
Number two,
right.
By constitutional provision, section 258 of section 7 says that by the time you file, 60 days from the time you file must be decided.
Okay.
And that time lasts on 17 January 2020.
Just a minute. Let me
doing academic
right,
exercise.
I understand all that. Let me bring Emeka Ihedioha in. You made some points there, and I wanted him to pick up on that. He talked about you introducing a fresh argument about this fraud part, which you never introduced at the tribunal stage or at the appeals court stage. That's number one. And number two, what about the argument by his side that the Supreme Court no longer has the jurisdiction to entertain any application relating to the Imo governorship election because it has passed the 60 days provided for in the Constitution?
Now, first of all, the law applicable with respect to fraud is that when you discover fraud, it is not held by time.
Right.
That is a different thing altogether. Now, people are
But you didn't introduce that fraud when you were winning.
It was there.
You only introduced it after you had lost.
When somebody said
right.
that these documents that you are bringing here, we are not part of it. We never produced these results because these results never existed.
Right.
What he's saying is that you went and produced it from
then you bring the original
hold on. Let him make his point, please.
Now, that is that. Now, we are not talking here about review. We are talking about setting aside judgment that was obtained by fraud. Now, there is also another issue. These are the facts. Now, before the Court of Appeal, there was a cross appeal. And the Court of Appeal, in deciding that cross appeal, struck out the petition of Hope Uzodinma. That is there. Now, in the rush, I believe the very learned justices of the Supreme Court, because of not having enough time that day to properly peruse the...
No, don't insult the Supreme
Court. Hold on, let him make his point, please. We haven't got that much time, so make your point quickly.
They are human beings.
Right.
And that is why the rule is there, that if subsequently you discover fraud, or you discover misrepresentation, or you discover something that ought not to be there, that they were misled, that you can come. The rule is there. A rule is made. We say, okay, this is a crime against stealing. It is done because we know
very quickly, we're almost out of time. What is your level of confidence that the Supreme Court is going to make a decision that is courageous rather than shameful from your point of view?
Now, I want to say something. This is not about prestige. This is about the foundation of our democracy. Okay. And I believe the Supreme Court, if they are not swayed by politics And I know they will not be swayed by that.
Okay, very quickly, we're out of time. Ahmed Gulak, a final word. Hold on, a final word from you.
For lawyers to begin to cast aspersions on the Supreme Court. No. The Supreme Court is an institution that we revere and must protect. The Supreme Court had taken all issues canvassed at the Court of Appeal and decided that Uzodinma won that election. That was the final judgment of the Supreme Court.
Okay, I'm going to have to stop. I'm really sorry, we're out of time, but we'll have to wait and see whether the Supreme Court will take a courageous or a shameful decision. Thank you very much, Ahmed Gulak, and thank you very much, Emeka Opara. Well, that's it for this edition of the Arise interview. Do join us again tomorrow. From me and the entire team here in Abuja, a very feisty discussion today. Goodbye, and thank you for watching.